waiting for it to officially start, anybody tell me, anybody want to share what had them come and spend this hour here this morning?
Why don't we wait until...
You need to set up whatever you want.
Why don't we wait until we introduce?
That's fine, perfect. Anybody else? Yes?
I just 3 things. I just rewrote the will.
You just wrote the will?
So I want to find out if I did the right thing.
Okay, fair enough. So, okay, we'll talk about that. All right, questions are invited. I know there are people still coming in, but for years, I've been a facilitator. I've only been, well, I don't want to steal Ron's thunder because he's going to officially introduce me, but I was a professional facilitator for about 30 years. And I want you to know I'm still 39 years old, so I started very, very, very young. But I got 3 ground rules for any workshop. One was to cheat, which means if somebody has an answer that you're looking for, do not think you can't use it. One was to interrupt. How many in this room are habitual interrupters? 1, how many? Oh, point at her. 2, okay. So here's what I learned a long time ago, very, very seriously, is that I'm an interrupter, but it's a cultural thing, a family thing. But the thing is, if we're in a learning environment, like this lady wants to know if she did her will right. If we think of a question and we don't get a chance to ask it kind of in the moment, the only thing we pay attention to until there's a break, whatever that's called, is the question. And then we often miss the thing we really wanted to hear while we're paying attention to our question. Oh, I really do invite people to interrupt. I will not stop at that second. I will stop at the end of a thought to answer the question because I want you to get your questions answered. And I don't have to be anywhere till 3 o'clock this afternoon, so I'm not going to keep you that long, but I'm just saying if there are questions you don't get answered in the hour, by all means, find me afterward. If you've gotten a business card, just call me, email me, that kind of thing. Oh, and the 3rd ground rule after cheat and interrupt is to have fun, because if we're not going to have fun, there is no point in being here. So I don't know what that looks like for you. I can take off my shoes and do jumping jacks or something like that, but didn't bring chocolate again because I didn't know how many people we'd have. But I'm really excited that everybody came. I'm really thrilled. 5 more minutes until we get started. We have 5 more minutes until we get started. Okay, anybody else want to tell me what had them come for this hour?
Yeah, how much can you inherit without having to pay?
Great question. How much can you inherit without having to pay estate taxes? In this moment, right now, today, $12,600,000 per person. Okay? That law sunsets on December 31st, 2025. It's not saying who's ever in office won't change it before then, and there's no way to know how much it might go down to. So people with a lot of money, and I don't know how to define that. Most people I know don't have anywhere near $12.5 million or $25 million for a couple. But if you have some substantial money, it's something to just be mindful of and pay attention to, because if the limit went down substantially, like down to $1 million or $2 million, some people might need to do some additional planning. Does that answer your question?
Yeah, give me five, yeah.
Okay, did you Cod? Cod, where are you from originally? Cod?
Ohio.
Ohio, Cod, okay. Anybody else have a question? And I'm being recorded now, so it's okay. So the people who are watching can hear. Anybody else want to tell me why they came? What does that mean? That means help, okay. All right.
Did you pass one of those papers back?
I thought you asked for one, if not, it's okay.
Who wants the paper? You do?
Anybody else?
Yeah, you're gonna, just want to pass one of those papers back here?
Oh,
We'll mix them.
okay, did you take one of each? Because they're right there. Does it only, well, see, okay, somebody needs to give Janet a copy of creating an estate plan because she's
I
gonna.
already have it.
Oh, I'm sorry, you already have a copy of both?
Already have it. I'll make copies later on during your time.
Ron's gonna make more copies.
Janet, why don't you
Very
do
good.
your little thing?
if you don't
Oh, I
go
guess.
on.
Yes, yes, you would.
Okay, I'm going to do my little thing, as he says. My name is Janet Warren. I'm chair of the Healthcare Committee, and we are bringing this presentation to you today. Thanks to Ron Sweet, who's known Debbie Baker for many years, is going to introduce her.
One says.
We sent out our 5th edition of Did You Know newsletter. How many of you got that newsletter? Yeah, I hope you enjoyed it. We had some really good contributors this time, didn't we? Yeah, and we had 4 pages. That's more than we've ever had. So I hope that you will look at the calendar at the end of the newsletter, because on that calendar we have all the events that we have planned for
I didn't
you,
get the 7.
and we hope that you will attend. We had a wonderful seminar on pain management, and that went so well that we're going to try to get a speaker every other month. So just be alert and hope that whatever we bring to you is meaningful to you and is of interest. So right now, I'll turn this over to Ron Sweet, who is a member of our Healthcare Committee. And on
One of the
behalf of our
hats-
Health Committee, I want to welcome all of you.
One of the hats I wear. Hi, everybody. I don't want to take much time. When I spoke to Debbie about coming out here and I asked her about what kind of slides will she have, she said, I'm not going to use slides. I want to get everybody's question answered. I don't want to just stand here and lecture. I've known Debbie over, well over 10 years.
Well, over 20 years, well over 20 years.
20 years, and it doesn't seem like that, but her mission always has been to help people. And about 8 years ago, when she graduated law school, I was thinking to myself, well, what is she going to do? She loves helping people. But I found out she found that niche to go out and help people our age and see what's going on. So I don't want to take a whole lot of her time. I just want to say, here's Debbie.
Oh, there's a perfect recommendation. Well, thank you, Ron. All right, well, let me give you a little history of me. That's fair. As I was saying earlier, my driving force is always to be of service. If any one of you were readers now or in a past life, there's a wonderful book called, I think it's called The Discipline of Market Leaders. I think that's what it's called. And there were 3 driving forces. There was profit, there was something else, and there was service. And I realized that my goal always has been to be of service, whatever it was. I've also always been the one who's been more than willing to tell people how to lead their lives. I say since I was 5 years old, I just don't know anybody anymore who knew me when I was 5 years old, because my older brother and my younger brothers don't count. And so I was a coach, an executive coach for well over 30 years. And it was wonderful. I would work with individuals or businesses to help them get where they say they wanted to go, mostly in the area of communication, because most of us are really poor communicators. If you've ever noticed that about the other people in your life, they may have noticed it about you. And I loved it. And I had really good results, and I never took credit for it. I always let my client take credit for the progress. And then in 2008, when I was trying to figure out, do I get a job or do I keep coaching? Because every once in a while, I would ask that question. I started believing in God in 1982. I became a Christian in 1984. So every once in a while, I say, do I keep coaching or do I get a job? And every time, honest, he'd send me somebody. Janet could call and say, listen, I'm really struggling with my committee. Can you come with my committee? Or Ron would call and say, I just can't figure out what I want to be when I grow up. And I know you don't ever recommend growing up, but I just don't know what my next step is. So it could be lunch, for which he would buy, and that would be the end of that. Or it could be Janet, and she might pay me a good bit of money to help her team, but that was either. Well, in December of 2008, in this query, I asked, what am I supposed to do? And God said, go to law school. So I was in my prayer room, and I looked around, and my cat wasn't even in the room. So I figured he had to be talking to me. And then I read a wonderful book called Walking with God by John Eldredge, where he says what we forget to do in conversations with God is we don't ask the next question. So you get a sense in your life that you're supposed to move from wherever you were to Florida, not business, and you instantly panic because you think you should have it all done by tomorrow. So my next question was when, and he said get ready. I had no idea what that meant, but I figured I could handle that. 32 months later, in August 22nd of 2011, I started law school. And I remember the dates because it was 4 of the most glorious years of my life. I forgot how much I loved being in the classroom. I was the oldest person in the room, so you weren't going to intimidate me by grades or standing or, I couldn't be bothered by that. I'm a first name person, so I had 2 professors who told me I couldn't call them by their first name, and I said, don't worry, I won't call you anything. I'll wave my hand and you'll call on me, or you won't call on me, that's up to you. And I had tons of fun, and I hated to graduate. I really hated to graduate. I just couldn't financially afford the wrath of my best friend if I didn't graduate with her, or another like $30,000 to spend another year to take the courses I wanted to take if I had the time for it in my first 4. So I graduated on May 16th, 2015. Ron was there at the party. Took the bar, passed. First time I was astounded that I did, but I was very grateful. And I chose this area of law for a couple of reasons. I don't know if this is the primary, but I don't ever want to be in a courtroom. As many friends as I have who say, Deb, you are one of the best arguers we've ever met. You belong in a courtroom. It's like, no, not doing court. Absolutely not doing court. And this area of the law, whether you're 18 or 88, doesn't matter, is such a blessing of service. I met a woman yesterday I'd never met before, and we got talking about what are our greatest pleasures in life from our careers. And one of my greatest pleasures is to have people call me and talk them out of the fact that they don't need me. Like, you got it covered. You don't need me. Go live and be well. So that's kind of what I'm about. So we're going to talk about estate planning. I had a couple of people tell me why they were here. One said she just did a will and she wants to be sure she did it right. I'm not sure what that means. She would know. I don't know. But anybody else want to volunteer why they're here? And speak loud enough so I can hear, so I can at least repeat it back. Yes, ma'am.
Yeah, my husband died a year and a half ago.
Okay.
And that's the last time I made a will. So
Okay.
clearly, I need a will, and I need to think about what other financial situations
Okay.
that they may not be covered.
Okay, so her spouse died about 18 months ago, and she hasn't done it, and she hasn't looked at her plan, hasn't updated whatever she's got since then. And she's right. Again, in that situation, it may not be that anything major needs to be done, but if her husband served every role that would exist in an estate plan, then she wants to replace him somehow with that. Okay, why else did somebody come? Anybody else? Okay. So there are basic ingredients of an estate plan. All right, some parts of their execution are unique to Florida or unique to only a couple of states, some not. But the primary one is having a last will and testament. And that's where you write down how you want your bounty, it's called. Your bounty, it's called. So again, oftentimes what happens when people get older is their families doubt their mental capacity, whatever. So it's like finding out, do you know what you said you wanted to have done with your bounty? And you say, yes, I want my son to get it all. Well, that's pretty clear, assuming the son is the only child. Or the question is, do you have other children and you're just leaving them out? And they say yes. That's pretty clear, okay? But a last will and testament is how you want to have your bounty disposed of. Real property, your homes, your condos here, all your intangible assets, your IRAs, your retirement funds, whatever you have there, and how are you going to do it? In Florida, the person you name to fulfill that role, which in Florida is called a personal representative, and for those of you who have documents from other states, they may call it an executor, same position. That person must be a blood relative of yours, not of your spouse's, wherever they live, or be a resident of the state of Florida. Yeah, wow, I'm hearing, right. So
Weird.
one of the things I did was updating an estate plan. So people move, or you've done documents a long time ago, and those people were perfect for you. They were spouse or spousette, the female version, or they lived in the state of Florida, or whatever. But when you look at that, even a few years later, you find out that, oh my gosh, that best friend whom you've had since you were 5 moved to Georgia. They are no longer eligible to serve. There is no reason, anytime, like what I'm speaking, if it goes through your mind, I didn't know that, there is no reason for you to know that unless you work with it all the time. There's no reason for you to know that. Okay, so that's stuff that's unique to Florida. The other thing that shows up, which happened this morning, I had a friend who's been telling me for close to 8 years that he wants to do his plan. He texts me, which I hate, text me and say, I'm ready, I'm leaving town on May 6th, I'll be back, and then I'm leaving on June 6th. So I thought meant he was going away for like a few days in May, and then he was leaving for good. He's a single man, he's got the financial wherewithal, he's been traveling the world for years, for like 6 or 7 months at a time. So I thought, fine, tell me what you need, we'll get it done before June 6th. So when I called him this morning, because we had a miscommunication on the text, he said, oh, I've got it all taken care of, I don't really need to do anything, I thought we could do this easily between now and May 6th. And I went, we're not doing a trust between now and May 6th. I mean, I'm just telling you, okay? And when we talked for a few minutes, what he's got 2 residences. He's got his homestead, and he's got a rental property. And he says, well, I've got them covered in my will. So for those of you who have wills, and you say, my children get my condo, my children get my summer home, winter home, whatever, in a will, you have now created probate for them. Probate in Florida is a dirty word because Florida is not what they call a probate-friendly state. So it can be expensive and it can be time-consuming. So there is a way in Florida for you to pass on ownership of property, real property, to whomever you want while you maintain all of your homestead rights, and then when you pass, upon presentation of a death certificate, that property becomes owned by whomever you've designated. That is a lot less expensive than probate. And what I tell people is, so you've probably noticed I have a reasonably flip sense of humor. If you hate your family, please don't do anything. Because they will pay the price and they will continue to dislike you even more. You just won't be here to listen to it, okay? If your family means anything to you, then you might want to consider doing it, reviewing it, updating it, changing it, whatever. So anyway, that's the will. That's what a will does, okay? The next document generally is a power of attorney. In Florida, Florida has what we call durable powers of attorney, which means they go into effect as soon as you sign them, and they are about giving people access to your financial world. You better trust the person you give that power to. I have a client, I think it took her 3 years to tell her niece that she'd made her power of attorney because she didn't want anybody looking at her finances. That's okay. But you have to trust the person you give it to. And it's called durable because it continues into effect if you become incapacitated, however the medical community might define that, okay? Prior to 2011, Florida had something called a springing power of attorney, which meant it did not go into effect until you were declared incapacitated. I think, though I don't know, this is my guess, is that the legislature changed that because if I become incapacitated and somebody needs access, you were spending valuable time getting it through whatever channels that were. So for anybody in this room who has a power of attorney that did not go into effect immediately and does not last past incapacitation, you might want to look at that. Powers of attorney for a community like this also include the right that you've given somebody to, God forbid, apply for government benefits. You've already given them that right to apply if need be. And what I've learned, when I took elder law, I took one class in elder law in law school, and it was very fascinating, and the professor, who's wonderful, wanted to know how many of us would do Medicaid planning. And I was a no at the time. And I've since learned that there are very, very valid, helpful, reasoned reasons why people allow Medicaid to be applied for, because you can bankrupt yourself, private paying for everything. You can bankrupt the whole family. You can wind up with all your good intentions, spending everything you've accrued, whatever that looks like, doing the right thing when there are government plans available to you, which also protect your spouse if you're living, because in a Medicaid situation, when you're married, your residence is always safe, and one vehicle is always safe. They cannot take that away from what they call the community spouse. So powers of attorney will include language that allows for Medicaid planning if need be by the person you've designated. And I put it pretty much into all my powers of attorney. It's not necessarily based upon age. Sometimes I've done it because somebody's been not well, and that could be 30s, 40s. You just want it in there, because the last thing you want to do is have your designated agent, they call it, show up at an attorney's office and they say your power of attorney doesn't give you this right. Okay. So that's the second document. The third yes.
Alternate person or a second power of attorney?
I always recommend backups. I always recommend you have a primary and then a backup.
What's the backup called?
Successor, yeah, okay. And there are people who don't have anybody, but I always recommend you have a primary and a successor, because then again, what happens sometimes, I haven't experienced this yet, but I'm sure I will, is that your primary person is willing to serve, but they're so caught up taking care of you or managing things, they don't have the emotional bandwidth. So it's good to have somebody appointed who can take their place so that you're not looking for somebody. Does that make sense? Okay, so the third document in the kind of the pantheon is a healthcare surrogate. And that's the persons you've designated to make healthcare decisions for you if you're not able. The thing I've learned recently, which I suggest to people just to consider, is that in the world of successors, that you consider having, like you appoint me primary and you're going to appoint Ron's successor. If you trust that both of us would make the same healthcare decisions for you, you might consider appointing us as co-healthcare surrogates. I had somebody recently do just that, shake their head, no way. Okay, so co-healthcare surrogates, so again, if one is not available, the other doesn't have to go through some legal stuff to be appointed, and then one decision is binding. I'm not saying it's good for everybody, I'm just recommended. And I had a client this week say, no, I'm first. We'll let our son come next. He's not co. Yes?
Do they both have to agree?
If you appoint co's, one decision would be binding. If you appoint one, then that decision supersedes, is more powerful than anybody else.
So you have two, they don't both have to agree.
No, well, you could say they both have to agree, that's a choice in the document.
Okay.
Okay, that's a choice in the document. So the healthcare surrogate is the one that has access to your medical records, has access to your doctors, and makes decisions for you. I recommend that people give people that power immediately, because you just never know when you're gonna be run over by a golf cart, right? And if I just looked at somebody who had that happen, I apologize, I didn't know that. Yes, sir.
In absence of that healthcare surrogate, what's the Florida law for a couple? Is one spouse that
Good.
legally considered the surrogate even without this document?
Yes, but yes.
I'm not saying don't do it.
Spouses can act for each other. Yes, here's your problem, which you see in the community a lot, or you see in your families. People who cohabitate, who do not have documents, are playing with grief. Huge grief. Because if you've been, I have a couple of probates that are about this now, they lived together for 25 years, no, longer. They bought their house 25 years ago. They never changed the deed so that they never married, but they never changed the deed to be joint tenants with rights of survivorship. She's gonna lose the home, it's cost her money. The stepchildren own half of it, they're gonna wind up selling it, and if he had done that, she could have sold it and had all the proceeds. As it is now, she's only gonna get half the proceeds. And I learned, legally, title agents can't say to you, you wanna do this as joint tenants with rights of survivorship. They probably can suggest to you, why don't you talk to an attorney before you let us do the deed? Like, the deed, okay? So no, spouses can speak for each other, yeah.
This doesn't apply to our living in Freedom Plaza.
Probably not. I'm not sure, but I haven't seen all your contracts and stuff, probably not. So that's your healthcare surrogates. Your HIPAA waivers are just what they are. How many people do you want to have access to your doctors? All right, well, I have a client, 3 children. They adore their daughter, and they have excluded their daughter from any right to talk to anybody about anything. She will take it up with her brothers because she drives her mother crazy, and she figures, I'll let her brothers deal with her, I'm not having my doctors deal with her. Perfectly okay. Other people will choose, even if they haven't named one of their children to be a surrogate, they'll give them access to the doctor. And a couple have even allowed in-laws, like daughters-in-law, sons-in-law, to do it, partly because, again, the whole idea of the planning is to spare your family as much grief as you can. So again, if you trust your family and your spouse is the one who's related to the person who's ill, then let their spouse at least talk to the doctor. But again, I don't push it either. One of the things I loved about being a coach, somebody asked me this recently. When I was a coach, I could say, I don't think that's really smart, Martha. And she would, whatever. As an attorney, I really can't say it. I might say, are you sure you want to do it that way? But I'm not having anybody sue me for what they call undue influence. Like I forced the issue. So you've got those 4. You've got your living will. So your living wills are the documents that talk about end of life considerations. They go into if you
have, in your doctor's office, you always put down who you want to see your medical records.
And if you have that, do you need to put it in your will and under your HIPAA?
Well, it's not in your will, it's a separate document, and I say yes. There are probably attorneys who agree, because what happens if you're on vacation? So the thing is, I recommend you do them regardless of whether you have it at your doctor's office. If you go into a hospital for surgery, you're gonna sign theirs as well. I recommend you have one of your own for all of them,
Okay.
okay? And
Thank you.
and you share them with the people you've named to represent you, so they know what you want. So Bay Care has some interesting additional provisions in their living wills, which allows you to choose whether you want CPR, whether you want surgery, whether you want antibiotics. General living will just wants you to say with an end-stage condition which has one medical definition, or a terminal condition which has another medical condition, or a persistent vegetative state. So for those of you who've been in Florida long enough and know about Terry Schiavo, she was a persistent vegetative state. She had a massive stroke when she was 30, something like that. And it wound up in the Supreme Court because she never signed a document which, reasonably enough, at her age, it didn't make sense to her to sign one, to have one. And so her husband had to fight. Her parents were absolutely convinced that she was sentient, that she was able, and they fought her. I'm not saying who was right. Had she had the document, it's not that her parents would have not filed a suit. It's that it probably wouldn't have gotten nearly as far or taken nearly as long as it did because she'd signed the document. Yes, ma'am?
Excuse me, where do you get these papers?
Well, some people get them online. I kind of cross my fingers. It's called a living will.
We have them over here in our nurse's office. If you go see Lisa, she has those documents.
Okay, there you go. Yes, sir.
They're also called advanced directives.
Yes, the set of them is called advanced directives. Absolutely right. Your healthcare surrogate, your living will, HIPAA waiver, all under the moniker, under the name of advanced directives. Thank you for that. Okay, and then a couple of other documents I do is, any of you who own anything that you really like, and you know who you want to have it at some point, I say, give it away now. Now, why do you think somebody might say that? Because they don't fight over it. That's one reason. That's the more calculated reason. They don't fight over it. For me, the other reason is, if you have something that you knew and you know I would love, why not give it to me while I can enjoy it, while you're still living, and then enjoy it differently after you pass. So, but I always recommend that. And then people say, well, nobody will want anything, and that's possibly true, but people do argue, and I think in one of those handouts, people will argue over the smallest things. May none of you have experienced this, but if you have, you know what I'm talking about, right? Because Mom had a clock that she bought, I gave her for like her 30th birthday. And my twin sister comes along and thinks that because she's my twin sister, she has a right to that clock. And she gets to Mom's after she dies before I do. And guess what? My sister and I stopped talking to each other over a clock that cost $3 or $5 back then. So it's not the monetary value. It's not, people think it's the monetary value. It's not the monetary value, it's the sentimental value. The other thing I found, which I have no study for, but I'm convinced it, I just don't care enough to do the research, is that the people who make the biggest fuss are the ones who have the least happy relationship with the person who died at the time of their death. So they do it out of guilt, they do it, who knows why. But if your relationships with the people who you love and who love you are complete, for want of a better word, you can bring them all together and say, here's the direction in the will. The oldest goes first, second, third, fourth, and then you each choose an item and go from there. Now, you can trade, but go from there. When my mother died, her attitude was, it's a personal problem, I won't be here, argue about it. That was my mother, very typical, very typical. And my brothers and I had the most fun time because it turned out she never gave away anything that we gave her, which was a result of her mother giving away anything she gave her as soon as she gave it to her. So if Jack were my father and I gave him something for Father's Day, he'd call me proudly tomorrow and say, I want you to know, by the way, I gave it to Judy. So she never gave away anything. Let me tell you, we found some really funny things that she kept. The most funny of which was this disgustingly metallic blue corkscrew pig with obviously very faint, non-jewels, but stones in them that my brothers had bought at a school like Christmas sale, probably for a dime. Back then it might have even been a nickel, okay? Now they didn't fight about it, but she had it. It was hysterical. And we were very blessed. If she had things that were divisible by 4, everybody got 2. Obviously, totally ruined any value it might have had. But if we gave it to her, we got it back. If 2 of us gave it to her, we kind of flipped a coin. But all families are not like that. And I know families who stop talking to each other over stuff like that. So I recommend give it away. It's not in your house. Possession truly is not 9/10 of the law, but that's what people would say. Possession is 9/10 of the law. Mom gave this to me 20 years ago. You're out of luck. Or just to stave the arguments. So, but part of my plan includes a separate writing memorandum, and that's where you list where you want everything to go. So your executor can come in and disperse. Okay. There's one called the Declaration of Pre-Need Guardian, which is kind of a reiteration of your will. It just says who you want to be in charge of your body and your person and your property should you become incapacitated. And again, that idea is to stop arguments. Here what I learn when I work with families with young children, you need to appoint guardians for your children. Who's going to raise your young children if you're not here to raise them? So what happens is you've got children. One spouse has a sister she would trust with her children, absolutely. The sister, however, is a modern day hippie, whatever that looks like, okay? But for raising the children the way she'd want them, without a doubt, okay? My husband has a sister who looks really good on paper, really good on paper. She's got, I want to say June Cleaver, Harriet Nelson kind of thing. She looks really good on paper, all fit together. She's got a career, good home, plenty of space for the kids. Neither one of them would trust his sister near their children. Her marriage is not great, whatever. So, but the judge who makes these decisions only has paper to go on. And he's going to choose the sister that neither one of them wanted. The same idea, when you're older and need a guardian, you want to choose, because what happened? The family I mentioned who excluded their daughter from HIPAA waiver, excluded her from being a guardian as well. Okay, so you want people you want, and you don't want somebody showing up who said, well, I'm Debbie's sister, and I know she wanted me to be in charge of her money or her property. And it's like, well, she named friends and your family, so how do we discern? So the Declaration of Pre-Need Guardian, and the last one is about once you pass, what do you want to have happen? Do you want to be cremated? Do you want to be buried? Do you want a service? Do you want no service? Many people are veterans. They have already gotten contracts and agreements to be buried at Bushnell or Sarasota or Arlington or something like that. They have family crypts. They have contracts. They pay pre-need. For anybody in the room, and I recommend this to 30-year-olds, this is not about age, you do yourself a favor and your family a favor if you prepay for all of that stuff. Okay, now, here's the thing. Once you pass, you may or may not get cremated. You may or may not get buried, but you've expressed your wishes, okay? And if you prepaid, it's more than likely that your family will do it. How many of you have experienced somebody dying and the family spent thousands and thousands and thousands of dollars because there was nothing prepaid, nothing pre-planned? Okay. Okay.
Question over here?
Yeah.
If a couple is divorced as far as the guardianship,
Mm-hmm.
and one passes, does it automatically, the guardianship go to the surviving ex-spouse?
Okay, probably not. Well, if you haven't changed your documents, possibly. The things that stop when you pass, if you've got an ex-spouse, is they can no longer, I don't think they could be your executor any longer. They can't represent you on your will. The thing that happens, or if you still have an amiable relationship, once the marriage is dissolved, you can reappoint them as
Can you
that.
repeat the question?
Yeah, I'm sorry. So the question was, for guardianship, if you have an ex-spouse, can that person still be guardian? Probably, but I don't know. But I do know that in Florida, if you have an ex-spouse, they cannot be your personal representative unless you've reappointed them, like after the dissolution of the marriage. Okay. The thing that happens oftentimes to the point of ex-spouse is, if you have an ex-spouse and you've made that spouse a beneficiary for anything in your world, bank accounts, IRAs, life insurance, that supersedes everything. So if you haven't changed that after a dissolution of marriage, that ex-spouse, loved or not, gets that money no matter what. So, yeah. Yes, sir.
I have a question about power of attorney.
Power of attorney, okay.
Does it have more power than if all of my investments have dual names on it, who they go to?
Okay, so the question is,
Does the investment company that I use have power over the power of attorney, or does the power of attorney have more power than the company that's holding it? Because all of my designated people who are to get my investments are on my investments. Which has the greater power?
okay, so your power of attorney absolutely loses all its power the moment you die. Okay? Okay, so that's one thing. But beneficiary designations supersede everything. They override. That's why people think I left all my money in my will to my favorite brother, but my beneficiary designations are his wife, let's just say. Which they wouldn't be because, well, my favorite brother may be. My least favorite brother, no.
The only problem I have is the beneficiaries don't know that they're on it.
They don't have to know that they're on it. So,
But that's superseded.
but the thing is, okay, so that's a good question. Your beneficiaries don't have to know that they're beneficiaries. My understanding, and I have to research this because somebody told me this is not true, and I don't know, is that those financial institutions are supposed to find those beneficiaries, which is one of the reasons I asked for social security numbers, because they can find you by your social security number. But the point is, nobody can have that money except the beneficiary. The challenge, to your point, is, again, people name their children beneficiaries, and what they don't consider is the horrific possibility that their children predeceased them. So they don't have the next level down, which are called secondary beneficiaries, contingent beneficiaries, successor beneficiaries. It depends. And I really recommend, so the guy I talked to today who wanted something done in 6 days, he's got everything beneficiary designated. I said, and he thinks he needs a trust. I said, I don't think you need a trust with what you've just told me, and we can take care of your homes, but your grandchildren, of whom there are 2 at the moment, are 9. They cannot inherit money until they're 18. I said, so you might need a trust if you wouldn't trust your daughter-in-law to manage the money well as guardian of the property if your son dies before you. He said, absolutely, I'll trust her. I said, well, then I can't think of a single reason you need a trust. I mean, you know, he doesn't have $25 million. He's not even close to 12.6. So again, you know, in 2026, if that threshold dramatically decreases, then yeah, maybe, but not to consider now. But no, beneficiary designations take over. You have another question?
No,
Okay, all right, yes, sir.
If a child is a beneficiary and that child is deceased, isn't there terminology called persterpes where it goes to the children of the deceased child?
Yes, yes. It automatically goes to the children of the deceased child. The challenge is if there's those children under the age of 18. No, absolutely. That's why his grandchildren are 9. As long as he trusts his daughter-in-law, God forbid, his son dies before his daughters are 18, then he's fine. And the other thing to consider, depending, is if you know that you have money that you want to go to grandchildren regardless, okay, a trust could be a good idea because you may remember when you were 18 and that you weren't going to carry more than a $20 bill because you would spend it. But actually, you would carry up to a $20 bill because anything over that was way too much money. But you knew you couldn't be trusted with substantial amount of money, however you define that. So you sure don't want your grandchildren to get a substantial amount of money when they're 18. And they would inherit automatically once they reach majority or adulthood. And I want you to know that even though all of our driver's licenses, whatever, say we're over 18, you gotta think the last time you had a snit, or a hissy fit, or a temper tantrum, or pouted, or whatever it was, you were not acting adult. Just think about that. So you want to think about, do you want young adults to inherit money? And that's a reason for a trust. Because then you could say, they get X dollars at this threshold, they get Y dollars at this threshold, they get Z dollars at this threshold, and they get it all at, A prime, okay? And it's more expensive, you have to have somebody manage the trust, but or if you have lots of property and you just, you just put it in the trust. But, so that's kind of that. Yeah.
With, and I'll call it a revocable trust, if all the assets are in there, does that not avoid probate?
Yes. If you have a revocable or revocable, however you choose to pronounce it, whatever, okay, which is a good place to be from, I got it. I learned every self-respecting New Yorker is born in Brooklyn. They may only live there for 3 days, but they're born there. In any event, and until they were annexed by the city of New York, they were the 6th largest city in the country. By itself, Brooklyn. In any event, useless information, everybody should have that. Elmo Flick was the 1905 American League Baseball batting champion. Everybody should know that. Okay, so revocable living trust. The reason for a trust is it keeps everything out of probate. If you have a trust, none of that information is available to the public. If you only have a will, that's public knowledge. So people can look at your will and see whatever. So what happens there is they see that there are beneficiaries and people start reaching out to them like, do you want life insurance? Do you want this to do that? But not everybody deserves a trust, needs a trust. And it's revocable, which means you can do anything you want with it until the day you pass. Because you hold 3 roles in the creation of a trust. You are the grantor, so you're giving whatever it is. You're the grantee, you're receiving it, and you're also the beneficiary. And you can change it at will, no pun intended, whenever you want until you pass. Then it becomes irrevocable and people can't change it. But yes, sir.
Non-resident trustees, are they qualified to act in Florida?
Yes, your trustees do not have to be Florida residents, but they cannot be your personal representative in Florida, unless they're a blood relative. Okay, yes ma'am.
How often do you have to have your trust updated?
How often should you look at it? I really like that question. Every 3 to 5 years, no longer than 5 years. And here's what I've learned. Going back to, you look at a will and you realize your best friend has moved out of state 10 years ago, but you've never looked at it. Or somebody's died, or you've named a trustee. Right now I have a friend who did her trust 20 years ago, and they were both about 45. And now he's in his early 70s, and she said, oh my gosh, I need to find another trustee. Well, at the time, her sons were way too young. They might have been over 21, but they weren't nearly mature enough. So every 3 to 5 years, no more than that, just to be sure. And it doesn't mean anything needs to be changed. You know, it may be that this lady over here may have documents that actually work. She might only need to do a will again, just so she puts her second person in first place, just for clarity, and then she doesn't have to provide, nobody has to provide her husband's death certificate when she passes. But it may be minor, you know, minor changes. Got another one?
With life insurance, you name a beneficiary. Is it well to just keep that out of the trust, and the beneficiary would get the proceeds of the life insurance upon the death of the person?
Yeah, okay. If you've got a beneficiary on your life insurance policy that's not the trust, yes. But the thing there is to name the trust the secondary beneficiary, so that if your first beneficiary passes, the money goes into the trust.
But then it could go to the children, is the terminology for children?
Well, okay, again. So here's the thing. Okay, so where would it go? Okay, so I'm his daughter, and I'm the beneficiary of his life insurance. Okay, and I've got 3 children. If I predecease, okay, it would go to the children, unless it says per stirpes, which I don't think they do. It would have to go through probate. So the thing to do is, if his grandchildren are of an age where he's comfortable, he names them equally contingent beneficiaries on the life insurance policy, and then it automatically goes. Okay, does that make sense? Okay, anybody? Yes? Wait, Ron's coming with a microphone.
Probate.
Hold it,
How do
hold
I
it.
stay out of probate?
Hold your thought.
How do I stay out of probate? For instance, my mother lived with us and passed away at the age of 101 and a half. She had a checking account to which my brother was on the account.
Okay.
That was it.
That was it.
There was a will,
Right.
and I did take the will to an attorney, and but he gave it to his partner who handles the estates, and then we never heard anything.
Okay, well, that's not good. Okay, so, all right. Probate, avoiding probate in Florida. Okay, again, if you have your, so this gentleman I talked about today who's got the 2 homes, he's got everything beneficiary designated with Merrill Lynch. We'll talk about whether he has contingent beneficiaries, okay? But right now I don't think he does, but he has everything beneficiary with Merrill Lynch. He's got, I think he's got his son or his sons as payable on death, they call it, with bank accounts, should he die, so that money is taken care of, okay? The homes were his risk if he died, probate assets, not hugely expensive if that's all you have, but why bother? Why have the sons spend any money when they're grieving, or curse their father for not having taken care of something as easy as that? If your mother only had a bank account and your brother was the beneficiary and she owned no real property, then there probably wasn't need for a probate unless there were other assets that had not been beneficiary designated. Okay, so I'm not excusing them not getting back to you, but from the little bit you said, there would be no need for a probate because she'd taken care of it by making your brother the beneficiary. Oh, here's another thing. Now, it may apply to you, may not apply to you. Do not, in good conscience, say, gee, Susie's my oldest child, and she'll be sure that her siblings get paid. Oh, no. 2 reasons. The emotional reason is, don't put that on Susie to get the money and distribute it. She's got enough on her plate grieving your loss. The calculated reason, you can't be sure they'll be talking to each other when you die, and you cannot guarantee they'll get their money. So all of them can hire an attorney and say, we were entitled to X percentage, and guess what? They have no standing. They have nothing to stand up on because it wasn't in the documents and it wasn't on the benefit. Even if it was in the documents, the beneficiary designation overrides. So if Susie got all the money, it's only because she's going to do what her mother says, or because she's still speaking to all of her siblings, that they'll get their share. Right now, I have a woman who is living with one of her 4 daughters, and this daughter seems to have gone off the rails somehow. And the mother did a will, because she did all the documents, and she left 25% of whatever she had at the end to this one daughter. And I think she's named all 4 daughters the beneficiary on her bank account, which is I'm talking nominal, probably less than $1,000. She didn't want to own the daughter, perfectly fine, but given the state of the sisters' relationship, if she'd put one of them in charge, it would have only, out of her love for her mother, that sister would have gotten a nickel. Because she had no. So do not put one of your children in charge of distributing your money. Just let the company, bank, wherever it is, just name them all equally and let them take care of it. It's no fuss, no muss. And I've learned if there are 4 of us and I show up with a death certificate, the institution must liquidate the entire account. They can't pay me my 25% and hold the other 75% until my brothers show up. No, they have to liquidate the account. So, I have no idea. Yeah, sir.
3 children, they're all
Wait,
beneficiaries.
Wait. 3 children.
Three children, all beneficiaries. One dies. Automatically, does all the money go to the other 2?
In a bank account, yes. It depends upon how to set it. It depends upon whether you can do joint tenants with rights of survivorship. You can do that with property. I don't know that you can do that with investments. Okay?
So it's not automatic.
That it would go. It's automatic. It would go to the children. I'm just not sure you can't designate it otherwise. So it would likely go to that deceased child's children. If that
no children.
Oh, then yes, it would go to the other 2.
Okay, thank you.
Yeah.
I just have shared experience in terms of beneficiaries. Make sure that whoever's your beneficiary knows it. Because when my husband died, one of his bank accounts, he made his son a beneficiary as well as me. And I didn't know it, and his son didn't know it. And the bank, as far as I can tell, did not make much of an effort to identify the son. The only reason I found out was I called them and I said, well, why didn't I get the entire amount? And they said, well, there's another beneficiary.
And they can't tell.
That's right. And I said, who? They said, well, we can't tell you that.
Did everybody hear that? You know, she's recommending, I saw you. She's recommending that you let your beneficiaries know so that they could be in touch because her husband died, his bank account was left to herself and his son, and she only got half the account when she called and asked why. Very reasonable question. They said, well, there's another beneficiary. When she asked who, they can't talk to her. And they weren't making much of an effort to find him. So, hold on.
An investment account that is joint tenants with right of survivorship also has a beneficiary named. Does the primary beneficiary have to be the same person as the joint tenant with right of survivorship? In other words, spouse. Or if I name my son as the beneficiary, but I've got joint tenant with right of survivorship, who gets the account?
Okay, so did everybody hear the question? Yep. Okay. If you've got an account that's joint tenants with rights of survivorship, who's ever the survivor gets the account. Okay? Now, once they get the account, they can change the beneficiary. Okay? Assuming they don't change the beneficiary, then when the surviving partner dies, it goes to the beneficiary. But once they own the account, and Florida, you can't, I don't remember what it's called in Florida, but you can't say in a legal document in Florida, if Joe contests this, he gets nothing. That's not allowed in Florida. I mean, it must be allowed in other states because it's not allowed in Florida. But no, once I own something completely, I could have promised you, there's no doubt our son is going to get it, you know, but there's no promise. Yes?
Bank accounts. Bank accounts. I own it, and my husband is, his name is on that bank account. Can I give that to my niece who is in the Philippines?
How do I do that?
You can give your money as a beneficiary designation to anybody.
Payable on death?
Payable on death. Payable on death. So the question is, if you're married and you have a bank account, okay, then your spouse might need to have a power of attorney to access that money in the event something happens to you. Because if you don't have a beneficiary, okay, it gets stuck. But if you get hurt, incapacitated, and he needs access to that account, he has no right to that account without the power of attorney. And lots of people, again, I know people who are in their 30s who have accounts only in their name. It's dangerous, because if something happens to them, their spouse, their domestic partner, whatever you want to call it, has no access to those funds without a power of attorney. Never mind the beneficiary designation.
Hello.
Hello.
It may be too soon, you're probably coming to this, but my question is storage. Where do you keep these documents, and should you give a copy, and do they have to have the original to be effective?
Okay, that's 3 questions. Okay, what do you do with the documents? You put them in a safe place, whatever that is, which is not a safe deposit box. Okay, now, when I do that, because can you access a safe deposit box after 6 o'clock on a Friday? Or on Saturday at all, or on a Sunday on a legal holiday? No, you cannot, unless you're the bank manager, and then maybe. All right, so here's what I do. I keep no original documents. There are attorneys that keep original documents. I am not one of them. I want no responsibility for your documents. Absolutely not. When they get executed, I keep PDFs. I scan them so they're on my computer. You get them back in a binder. And you get a thumb drive with all of them, okay? So I think the third part of your question was, do you give people copies, right? There have been couples where I've created a second thumb drive because they wanted whoever they've named to have a set. If you are not doing a trust, the only original that will ever be required is the will upon your passing, because it's supposed to be recorded with the county you live in within 10 days of somebody knowing that you passed. Years ago, when I first started in practice, I called one of the clerks and said, "Is that reasonable?" They said, "Oh, trust me, we do not insist upon that. Just don't worry. But you should record the will." Okay, but that's the only original. Everybody else should be able to accept a copy. Okay, if anybody asks you for, and you never unstaple the will because it's been deemed possible that I don't like what's in Jack's will, and he named the executor, so I get a copy, and I somehow manage in a Word document to modify that I only got half of everything, but I wanted everything, so, right? So you never unstaple your original will. If you have to make a copy, you do it the long, laborious way of going to a machine and 1 page at a time. But if somebody wants a copy and they must see the original, this is true with trusts. Oftentimes a bank will not let you bring them a copy of a trust. You bring them the original, you hang out while they copy it. I wouldn't let it out of your sight if you could avoid it, and you get back the original. But that way they're happy that they made a copy. Excuse me, psychology. Did that answer your questions?
Yeah, perfect.
Okay, thank you. Yeah.
Copies of that document. What if you have it notarized?
No,
Is that
okay.
illegal? Would it be
I don't know that they're the same thing. So she's asking about notarization. Pretty much every document I do gets notarized. Okay? Florida does not require, and I don't know if they do it here, does not require that healthcare surrogates and living wills be notarized. They only need 2 witnesses. Okay? What I've come to see is I'm working with people now where somebody might come in and say, this wasn't legitimate, it's not notarized. So I've taken on the practice of getting and I'm the notary, you bring 2 witnesses, I'm the notary, getting every document notarized. And they take pictures of that as well. And then you tell somebody who's going to be in charge, you put it in a home safe to where you store it. You put it in a home safe. you put it in a lockbox somewhere. Many people will give the originals to their children and the thumb drive to somebody else because the children live close by. They're the ones who are going to need access to the documents. Anyway, you do give copies of your healthcare surrogates and living wills to your primary care physician. And you might want to give it to the people you've named. So they know, back to knowing, letting people know that they're beneficiaries. Don't let somebody wonder if they've been named, and think, well, Mom wouldn't name me after all, I look too much like her, who knows why. But my brother Johnny doesn't know that he's named, and he lives in upstate New York, and he doesn't have any interest in the position. Oh, before you name people, ask them if it's okay. I have had one situation where somebody called and said, so-and-so named me their executor. We haven't spoken in 15 years. Why would they have done that? I didn't do the will. I have no idea. But you want to ask them before you name them, because there are people in your family or amongst your friends who'd be happy to take care of your finances for you, very legitimately with great integrity. Never wanted to talk to a doctor, don't want anything to do with those decisions. They can't stand the sight of blood. And if somebody teases you that they won't honor your wishes, really think about whether you appoint them or not. My opinion.
One more question, and then after that, they can meet with you afterwards,
Okay.
but there are other people who have meetings and luncheons.
All those things. One more question? Oh, yes.
You were going to tell us avoiding probate in Florida.
Oh, I'm sorry. I thought I did that. I apologize. I'll summarize it again. Avoiding probate in Florida. Everything gets beneficiary designated, gets secondary beneficiaries. So you have 2 steps down. You have done something with your real property, which is called an enhanced life estate deed. Lady Bird deed. It is named after Lady Bird Johnson, though she had nothing to do with it. The guy who created it just was looking for a name, and he named it Lady Bird. And that would say, so Ron wants to make me winding up owning his condo. So Ron as the grantor, he's giving the right, gives to him as the grantee and life tenant, okay, all of the rights that go with owning the condo, and the remainder beneficiary is really Deborah London Baker, because that's the name on my driver's license, and with my address and my marital status, but he keeps all the rights to do anything he wants with that residence. Okay? And again, I don't know that applies in here, as the gentleman said here, but if you owned a home outside, that you avoid probate like that. That's how you avoid probate. Does that help? Okay. Anyway, I guess hang around. Ron said we're out of time. I guess the hour's up on the video. And like you said, you have places to go. But I'll hang around.
We have recorded this, so any of you who, in a few days, we should have it up on racrep.org if you want to review it. Janet, do you have any last comments?
Oh, excuse me. For anybody who didn't get paperwork, Ron made more copies.
Thank you so much for coming.
Yeah, thank you.